Today we'll do the second paper, which is of the same year, but of 3 year. Okay. So this paper also you have to solve whether you are from 3 year or 5 year, because the questions are being repeated in the exam from the same topic. I will show that as well. Okay. So first question is here. Which article of the Indian Constitution deals with the disqualification of MPs from Lok Sabha or Rajya Sabha? Even if you don't know the answer, by making an educated guess, you can answer it. Now, from 1 to 51, I asked you to remember, right? So 1 to 51, if you remember, remaining option you can eliminate very easily. What is Article 10? Article 10 is continuation of citizenship, right? Which means that whoever is a citizen of India will continue to be a citizen of India. What is Article 20? Article 20 is protection with respect to conviction of offenses. Yesterday we talked about it. There are 3 protections which are there. First one is no ex post facto. Second one is no double jeopardy. And third one is no self-incrimination. Right. And then you have 32. What is 32? So 32 is right to constitutional remedies, which means that if your fundamental rights are violated, then you can directly approach the Supreme Court under Article 32, right? And when you are approaching the Supreme Court can issue writs, including the writs in the form of habeas corpus, mandamus, prohibition, certiorari, and quo warranto, right? So 102 will be the right answer. So even if you don't know the answer, by using elimination, you can remove this, but you can answer this particular question, right? Next question. Yeah, I think yesterday in 5-year paper also the same question was asked, right? What power does Rajya Sabha have with respect to money bills? What do you think is the answer?
It has no power.
Right. So it has no power. See, no power is again, not the right answer, because that is not mentioned in the Constitution. It is saying that Rajya Sabha can discuss it for 14 days, right? Within 14 days, you have to take action. You cannot reject it. You cannot accept it also. You just have to discuss and send the recommendation. That's it, right? So only 14 days time is given to Rajya Sabha to discuss on the money bill. So Rajya Sabha has no voting rights over a money bill, right? So that you have to remember. So I know this option is given to confuse you. See, when you say no power, then 14 days discussion power is given, not to them. So this option will be eliminated. So 3 will be the right answer. Next. Who was the constitutional advisor to the Constituent Assembly? I think I discussed this question, this topic in a greater detail. Very good, very good. So it is Sir Benegal Narsingh Rao or B.N. Rao, right? So B.N. Rao, he is the constitutional advisor or legal advisor to the Constituent Assembly, which means that when the members of Constituent Assembly, if they have any doubt on any legal topic or anything, so they will go to B.N. Rao and they will ask, dear B.N. Rao, I have this doubt. Can you clarify it for me? Right. So even when Ambedkar had doubt, he has to go and consult the legal advisor, that is B.N. Rao. Okay. So B.N. Rao is the right answer. And you look at this thing, Dr. B.R. Ambedkar. So he is the chairman of drafting committee. So what is the purpose of this drafting committee? To draft the constitution for India, right? And who is Rajendra Prasad? He is the first chairman of Constituent Assembly, and he is also the first president of India, right? Jawaharlal Nehru, who is he? First Prime Minister of India, right? Narsingh Rao, so he is a legal advisor to the Constituent Assembly or constitutional advisor to the Constituent Assembly. Next. The concept of welfare state is included under directive principles, right? Because in directive principle, there are many concepts which are aiming towards the welfare state, right? Let us say, for example, minimizing income inequalities, right? So prevention of concentration of material wealth and means of production, right to livelihood. So all of these things falls under the concept of welfare state. So DPSPs are about the welfare state, right? Whereas fundamental rights are civil and political rights. They do not talk about welfare state. Fundamental duties are the duties which citizen has to follow. It has nothing to do with welfare state. Okay. 8th schedule talks about official languages that are recognized by the Constitution. How many official languages are recognized as of today? 22. Right. 22 official languages are recognized. Very good. Very good. Next. Yeah, yesterday we talked about it. Sarkaria Commission refers to. Very good, guys. Very good. Center-state relation. Sarkaria Commission is on center-state relation. Yesterday I discussed it. Okay. See, after finishing this class, just go home and revise these things again. It will hardly take 5 to 10 minutes. Otherwise, you'll forget everything. Yeah. Who was awarded the Gruber Prize for Justice in 2002? So it is Fali Sam Nariman, FS Nariman, right? So his son, Rohinton Nariman, so he was a former judge of, the Supreme Court of India, right? So now he's not there. So now he's there, but he's not the judge. Okay. So Fali Nariman, he died very recently, right? Very recently he died. So this is also very important. And he'll ask this question about Nariman in the exam again. Who was the first Chief Justice of Telangana High Court? Very good. So Justice Tottatil B. Radhakrishnan. So T.B. Radhakrishnan, he's the first Chief Justice of Telangana High Court. If they asked this question in the previous exam, this year they can ask who is the current Chief Justice of Telangana High Court. Who is that? Justice Alok Arade. You have to remember this thing. Right. So Alok Arade, he is the present Chief Justice of Telangana High Court. Very important question. You look at this thing, V. Ramasubramanian. So he was also a judge of Telangana High Court and he was elevated to the Supreme Court later. Next. Ashby versus White relates to, I think we talked about this case when we were discussing law of torts. It is related to breach of legal right. Now, what do we call a breach of legal right in law? It is known as injury. Okay. So injury is violation of legal right. What is the meaning of damage? Damage is the
Loss.
Or loss, right? What is the meaning of damages? Damages is compensation, right? So what happened in Ashby versus White? Can somebody tell me if you remember? So in Ashby versus White, a person was stopped from casting his vote, right? So he was about to, very good, Dikshita. So he was about to go and cast his vote in the election, but he was stopped by White, who is a police officer, right? So, but what happened is that Ashby wanted to vote for a person and that person has won the election also, even though Ashby did not vote. Now, do you think there is any damage? Is there any loss? No, because he went to the polling booth to cast his vote to some person, but he has won. But what has happened here? There is a breach of legal right. What is the right? The right to vote, right? So right to vote is violated over here. As a result, Ashby filed a case against White and also got compensation. So in law of torts, if you want to get compensation, or if you want to file a case, breach of legal right or injury is important. Damage is not necessary always, right? So once your legal right is violated, you can go and file a case. Next, doctrine of pith and substance relates to. So here, doctrine of pith and substance relates to interpretation of statutes. What is the meaning of statute? Statute is law, right? So whenever there is a problem of competing legislature, right? So what is the meaning of competing legislature? Which means two people are trying to make a law on this one, but then the court will decide. I'll tell you how. See, now let us suppose that ban on liquor is a central subject, which means that only Parliament can make law with respect to ban on liquor. And now let us say, for example, a state government made a law banning the liquor. Okay, because many people are consuming alcohol and they are creating a lot of problem in the state. Right. Now, state government made a law, but do you think state government is competent to make? No. Only central government should make, but state government made the law. When such law is made, court will invoke the doctrine of pith and substance, wherein the court will see that, okay, if the substance of the law is good, right? If the substance of law is related to this particular jurisdiction, then court will say that, okay, this is good. Because now here the state is being affected, right? Because of the alcohol and liquor and everything. So the court will say that if the substance is good, we will give exception to jurisdiction. What is jurisdiction? Jurisdiction is a power. Who has the power to make the law? Central government. But in some cases, if the substance is good and if the substance is solving a particular problem related to that jurisdiction, then the court will allow, right? So doctrine of pith and substance relates to interpretation of statutes to solve the problem of competing legislature in the same field, right? So especially in subjects related to concurrent list also, this particular doctrine will be invoked when there is a conflict, right? However, there is a very clear, indication that whenever there is a subject in concurrent list and both central government and state government are making laws, then the central law will prevail always. Okay. Now look at this thing. The Constitution of India recognizes which type of minorities? Very good. Religious minorities as well as linguistic minorities. The concept of ethnic minorities is nowhere mentioned in the Constitution. We discussed articles 29 and 30, right? So there we talked about linguistic as well as religious minorities. Next. Which of the following schedules of the Indian Constitution recognizes official languages? You should be able to answer it. Just now I talked about it. 8th schedule, right? So 8th schedule talks about official languages. How many are there? 22. What is 6th schedule? Right. So 6th schedule talks about administration of tribal areas in the states of Assam, Meghalaya. 1 minute. Sir, hello. Sir, we could after 7 o'clock call, yeah, like I'm in a class, right? Yeah, okay. Okay, see, 8th schedule has 22 official languages, right? And then we have 7th schedule. In 7th schedule, there are 3 lists. What are they? Union list, state list, and concurrent list, right? So on union list, only parliament can make laws. On state list, only state legislature can make laws. On concurrent list, both parliament as well as state legislature can make laws. 9th schedule talks about land reforms. There are certain subjects of land reforms which are placed in the 9th schedule, right? And these 9th schedule, do you think 9th schedule was there in the original constitution? The answer is no, right? So this was added by first Constitutional Amendment Act, right? So this was added by first Constitutional Amendment Act. This particular, in the original constitution, there were only 8 schedules. You have to remember that. Okay. Next. Yeah. The control of expenditure of Government of India vests in. So the control of expenditure of Government of India is always there in the hands of Parliament. Already I told you, maybe I might not have discussed a Parliament chapter. Rajesh sir might have discussed. To draw even a single penny from the consolidated fund of India, from the government money, you need the approval of Parliament, right? So Parliament has the complete control over the expenditure of Government of India. Next. Mandal Commission refers to, yesterday we talked about it. Mandal Commission refers to reservation, right? So reservation for OBCs. So reservation for other backward classes. Mandal Commission talks about this. Next. Very important question. The power of Supreme Court of India to decide disputes between the center and state falls under Very good, very good. It is original jurisdiction. Now, what is the meaning of original jurisdiction? Jurisdiction is power. Okay. Original jurisdiction is that whenever there is a dispute between center and state, they can directly go to the Supreme Court, right? And here, this is original and exclusive jurisdiction, I would say, right? What do you mean by original and exclusive jurisdiction? It means that exclusive, only to the Supreme Court they can go, not to the high courts, right? Original jurisdiction is there under Article 131. Next, what is appellate jurisdiction? Appellate jurisdiction means that a case is tried and adjudicated in a lower court, and then you are appealing it to a higher court, right? So Supreme Court also has appellate jurisdiction, because Supreme Court is the largest or the final appellate court, right? So first you'll go to the lower court, then you'll come to the high court, and then if you're not satisfied, finally you can go to the Supreme Court, not more than that. So that is why Supreme Court has appellate jurisdiction also. But the dispute between center and state falls under original jurisdiction, because you can only come to the Supreme Court in the first place and not to other places. Next one is advisory jurisdiction. What is advisory jurisdiction? Whenever president has any doubt, he can come and consult the Supreme Court under Article 143, right? So I told you already, whenever president has any doubt, what he will do? He will go to the Supreme Court and he'll say that, dear Supreme Court, I love you. So under Article 143, he will get the advice from the Supreme Court. And the advice given by the Supreme Court is not binding on the president again. If he wants, he will follow. If he don't want, he will not follow. Pecuniary jurisdiction is jurisdiction with respect to money, right? So lower courts has lesser pecuniary jurisdiction or monetary jurisdiction, right? If you go to a higher court can decide cases which are related to more money, right? That is known as pecuniary jurisdiction. So center and state, any dispute between center and state falls under original jurisdiction. Which landmark case is celebrating 50 years in 2023? Can somebody answer this? I know that I already told you that this question will come and has already come in the exam. So it is Keshwananda Bharti case. On 24th April 1973, Supreme Court delivered its judgment in Keshwananda Bharti case, right? So last year also I told my students that this question will definitely come in the exam, and this has come already, right? So because last year we were celebrating the 50th anniversary of Keshwananda Bharti case. Keshwananda Bharti case is known for, the evolution of basic structure, right? So basic structure doctrine was evolved in this particular case. If you look at other cases, Berubari case is actually not a case. It is a presidential reference. President asked the Supreme Court certain doubts, right? So in Berubari case, Supreme Court told that preamble is not a part of the Constitution. Preamble is not a part of the Constitution, according to the Supreme Court in Berubari case. In AK Gopalan case, we discussed about AK Gopalan case. In AK Gopalan case, Supreme Court has taken a narrower interpretation of Article 21, where Supreme Court has applied the principle of procedure established by law, which means that whatever is there in the law, we will blindly follow it, right? If law is saying that I can kill you, I will kill you, right? So AK Gopalan tried getting an exception, but he did not get it. Then Menaka Gandhi case, in Menaka Gandhi case, it was held that right to travel abroad is a part of right to life, according to the judgment of Supreme Court in Menaka Gandhi case, right? So these cases are very important. Next. Very important question again. Representation of People's Act was enacted in which year? It was enacted in the year 1951. See, there are two Representation of People's Act. The first act, which was enacted in 1950, is related to, conduct of elections, right? Qualification of, voters and etc. Second RP Act, which was enacted in 1951, is related to election malpractices, right? So in 1950 Act, we are talking about everything till election. What should be the qualification of voter, where you have to post him, what are polling booths, and everything is mentioned in 1950. After election, that you have to remember as 51. The next one, if there is any malpractice in the election, dispute between two political parties, right? So these kind of things are dealt under The second, Representation of People's Act. Disqualification of members, right? How do you disqualify an MP? How do you disqualify an MLA? So that is given in the second RP Act, that is 1951 Act. Okay. So very important again. Next, who is the Attorney General of India as of today? As of May is irrelevant because this is last year's question. As of today, you tell me. What is the right answer? Very good. So R. Venkat Ramani is the present Attorney General for India. Basic things these people should know who are making the paper. For India, not of India. Okay. So Attorney General is a constitutional body or statutory body? So it is a constitutional body. Under which article this office is there? Under Article 76. That is also very important. Next. I think I discussed this topic also in very greater detail in our classes. The first meeting of Constituent Assembly was held in which year? 1946. Very good. On which day? 9th December 1946 at 11 a.m. This also I talked in the class. Right. So 9th December 1946 at 11 a.m. for the first time Constituent Assembly sat. Right. So what is the purpose of this Constituent Assembly? To make the Constitution for India. Right. Yeah, what is the meaning of layoff? So layoff is a concept which is there in labor law. Okay. So layoff means terminating an employee at the will of employer. Right. So who is the employer? Employer is basically the company. Company terminates, the employee. He'll say that the company will say that don't come to my office from tomorrow. Right. So that is known as layoff. Right. So this question was there in the news because recently a lot of startups started laying off their employees, which means they started terminating their employees, especially when this exam was happening. Right. So when this exam was happening, I was working for, I was teaching in one company, which is valued at $3.5 billion. Right. So it is a $3.5 billion company. When I joined, they have laid off around 1,200 employees. 1,200 employees were asked to go out. Right. So at that time, it was there in the news. So that's how, it is very important. Next. SR Bombay case is related to President's rule. Right. So in SR Bombay case, Supreme Court told that if state fails to secure secularism in a particular state, then it is a ground for the imposition of President's rule. So what is President's rule? President's rule is basically imposed when there is a failure of constitutional machinery in the state, which means that when state cannot function in accordance with the provisions of Constitution, then you will impose President's rule under Article 356. Okay, so this is very important. So which article talks about national emergency? 352. That is very important. Fundamental rights, 12 to 35. Next. Traffic in human beings is violation of. I think you should be able to answer it. Yesterday we talked about it. Very good. Very good. Right against exploitation. Under which articles? 23 and 24. 24 is prohibition. 23 is prohibition of human trafficking and forced labor. 24 is prohibition of child labor. Both of them are the rights against exploitation. Right. So do you think right to social justice is there in the Constitution? No, it is not there. Right to life, it is there under which article? Under Article 21. Right to equality, yes, it is there under Article 14. Right. So 14 to 18 basically talks about right to equality, and 14 very specifically talks about equality before law and equal protection of laws. Next. Yeah, very important question again. I think I already discussed it in the class and they asked in the exam. During national emergency, which of the following articles of the Indian Constitution cannot be suspended? Very good, guys. Very good. 20 and 21. 20 and 21 cannot be suspended. What is 20? Protection with respect to conviction of offenses. 3 rights are given. No ex post facto, no double jeopardy, there is no double punishment, and no self-incrimination, which means you cannot be forced to be a witness against yourself. And 21 is right to life. So right to life also cannot be suspended during emergency. Right. One more thing. Under Article 19, so this is the right answer. You cannot suspend at 20 and 21 whenever there is a national emergency. Under Article 19, there are 6 rights. Freedom of speech and expression, assembly, association, and movement, right? And residence, and also profession. So these 6 rights are there under Article 19. And these 6 rights can be suspended during national emergency only when national emergency is imposed on external grounds. Right. However, when national emergency is imposed on internal grounds, which is known as internal emergency, then these 6 rights cannot be suspended. Now, what is the meaning of external grounds? External grounds means that whenever it is because of war or external aggression, outside some problem is happening, as a result, there might be a threat to India. In such cases, you can suspend. But when there is an internal disturbance, you cannot suspend these rights. Okay. This is again very important. Very good. Next. And how many of you did the homework yesterday? I asked you to do the passages now. Did? Done? Okay. Which one of the following schedules of the Indian Constitution lists the names of states and specifies their territories? I think this is a very easy question. First schedule, right? I already gave you a mnemonic, which is known as Tears of Old PM. Tears of Old PM. If you remember this, schedules chapter is done, right? So first schedule talks about name and territory, right? Second schedule talks about emoluments, allowances, and privileges of members of parliament, president, vice president, etc. What is the meaning of emolument? Emolument is salary, right? Allowance is any special allowance that is given to you, maybe car or house rent allowance, etc. Privileges are some special powers which are given to you. When I was talking about fundamental rights, I told you that no civil or criminal proceedings can be initiated against president or governor. That is a privilege which they are having, right? Then third schedule talks about forms of oath or affirmation, which means that whenever you are entering into any constitutional office, you have to subscribe to an oath. You have to say that I am so and so, I will bear true faith and allegiance to the Constitution of India. There is an oath which is there for every office separately. They are mentioned in third schedule. What is fourth schedule? Fourth schedule is representation of states in Rajya Sabha. How many seats are given for each state in Rajya Sabha? That is mentioned in fourth schedule, right? So you remember this small mnemonic which is there in the class, right? You go and watch the recording and remember this particular thing. You will answer every question that comes on schedule in the exam. Now, this is the second question, I guess, on schedule. Last time he asked about 8th schedule. Now he's asking about 3rd schedule. So very important. You cannot afford to miss out on this. Yeah. Now, this is a very interesting case. R versus Tolson, right? So R versus Tolson is a case which is related to mistake of fact. Now, do you think mistake of fact is excusable? The answer is yes, right? So we discussed a very important legal maxim which says ignorantia juris non excusat. Ignorantia facti excusat. Which means that juris means law. Ignorantia is ignorance. Ignorance of law is not an excuse. Right? After committing a crime, you cannot say that I don't know that this is a crime. So that is not at all excusable. But ignorance of fact is excusable, which means that you don't know a fact. As a result, you have committed some wrong. Right? Now, let us say that that is a glass. And this is dark. Now, let us suppose that there is no light in the room. And I felt that that is a wooden door. And what I did, I threw a water bottle from here. And that has hit the glass and it broke down. Now this is the night time. So I am thinking that it is a wooden door because here this is made of wood. So I don't have any intention to break that particular glass. So in such case, I will get an excuse, but ignorance of law is not an excuse. So what happened in R versus Tolson case? So this R and Tolson, both of them were married to each other. Okay. And they belong to Ceylon, which is in Sri Lanka. And what they did for honeymoon, they went to England after their marriage. And when they were in England, wife actually got, sorry, this is which case I'm talking. Yeah, so both of them were married. And this is not related to the Ceylon case. I forgot the facts. Okay. In this case, what happened is that both of them were married. And husband left the wife for almost 6 years. Left in the sense he actually died in, according to the reports which wife has received, he died in some plane crash or he is not there. For 6 years, she was unable to find him. Now, what she felt is that he is not there, right? Because for 6 years, if somebody is not appearing, what does that mean? So now what she did is that she married another man. Now, marrying another man is an offense according to the Indian Penal Code. Of course, this is an English case, but under Indian Penal Code, according to section 494, bigamy is a punishable offense, right? So here, what happened is that after 6 years, after 11 months, 6 years and 11 months later, 11 months after the second marriage, husband appeared all of a sudden, right? So husband appeared all of a sudden and told that, see, you married another man when your husband is alive. So you are liable for bigamy, which is marrying twice. Then, this court was decided in the English court. Justice Stephen delivered the judgment. He told that this falls under the category of mistake of law, right? Mistake of fact. Because, see, for 6 years when I did not see you, it means that you are no longer there. So she is held that the wife is innocent and her second marriage was allowed. And she was not held liable for bigamy, right? So that is R versus Tolson. So it is related to mistake of fact. Yeah. Next one is Balfour versus Balfour. So Balfour versus Balfour case is related to contract. So in this case, see, when I say Balfour and Balfour, both of them are husband and wife, right? So both of them were married and they belong to Sri Lanka and they went to honeymoon for England. Okay. And when they went to honeymoon, what happened is that wife became sick and doctors advised wife to stay there in England itself. So wife stayed in England and husband told to wife that you stay in England, I will give you $30, sorry, not $30, 30 pounds. What is the symbol of pounds? 30 pounds. 30 pounds per month, I will give you as maintenance. So every month, husband is sending 30 pounds to wife. Suddenly he stopped sending. Now, when he stopped sending this thing, wife filed a case and she told that we entered into a contract that husband will pay me 30 pounds till I'll come back or something like that. And he stopped paying. Now, court told that these type of domestic agreements will not become contract, right? What is domestic agreement? Agreement between wife and husband, where there is no intention to enter into a legal relationship. In a contract, always there should be an intention to enter into a legal relationship. So legal relationship is you want to make a transaction with him, right? So here such thing is not there because she is my wife. I told that I'll give you 30 pounds, right? So that would not amount to contract because this is a domestic agreement and there is no intention to create legal relationship. Now I'll give you another example also. Now let us suppose that I told my son that if you get good marks in the exam, I will buy you an iPhone, right? And he got good marks in the exam, but I did not buy him an iPhone. Can he go and file a case against me in the court? No, because here, this is a social agreement or a domestic agreement because there is no intention to create a legal relationship, right? So that would not amount to a contract. Next, 73rd and 74th Amendment. In one chapter, we discussed about this in greater detail. What is that? Very good, guys. So local self-government, right? Earlier in India, there were only two tiers of government, constitutionally speaking. One is union government, and second one is state government. Now, by enacting 73rd and 74th Amendment, we created a third body that is known as local self-governments. At the rural level, we have panchayats, and at urban level, we have municipalities, right? Of course, we have 8 types of urban local self-governments, like municipalities, municipal corporation, cantonment, township, notified area committee, town area committee, right? So port trust in areas where there is a port. So local self-government was created by 73rd and 74th Amendment Act. Very good. Next question. A foreign citizen who is staying in India cannot claim the right to. What do you think is the answer? Very good. Well done. Freedom of trade and profession, right? Any and every trade he is not allowed to do. Equality before law and equal protection of law. This is available to both citizens as well as foreigners. Right to life and personal liberty is also available to both citizens as well as foreigners. Freedom of religion is also available to both citizens as well as foreigners. Whereas this right is available only to citizens. If you see the fundamental rights chapter properly, you will identify which rights are given to citizens and which rights are given to both citizens as well as non-citizens. Okay, so this is the right answer. Freedom of trade and profession. This is there under which article? This is there under Article 19, right? Equality before law, 14. Personal liberty, 21. Religion, 25. Next. I think we talked about this case in important case laws. Tell me, Vishaka versus State of Rajasthan. I told you that there is one lady and she was raped at her workplace. No, not related to rape. It is related to sexual harassment, right? So I gave you the facts of the case where there is a lady, her name is not Vishaka. Okay. So because see, whenever you take any case, the victim of rape case, especially rape and sexual harassment, their names are not disclosed publicly, right? So there is a judgment of the Supreme Court which says that you are not allowed to, showcase the name of victim because it will further create problem to the family members, right? So that there is through a person which is known as Vishaka, they filed a case. So a lady was there, she was working under government scheme, right? Under Mahatma Gandhi employment or something like that. And during her workplace, she was gang raped by certain women in front of her husband, right? And a case was filed in the Supreme Court, and Supreme Court has given certain guidelines related to sexual harassment. And today we have a law which is known as the POSH Act, Prevention of Sexual Harassment at Workplace. So this case is related to sexual harassment. I think with respect to adultery also we discussed the case, right? In the case of Joseph Shine versus Union of India, Supreme Court told that adultery is not a criminal offense, but it can be a ground for divorce, right? Next. '89, Advocates Act of 1961 deals with. Very simple, straightforward, and easily you can answer it, even if you don't know anything. First, you see rights of accused. Who is an accused person? Somebody against whom a case is filed. Now, advocates and accused, no relation over here. Of course, they'll go to the advocate. That is a different thing. Next one, relating to court and criminals. Advocates are not criminals, so this also eliminated. Rules relating to criminals and advocates, no. Ethics and rules relating to advocates. So what etiquette and ethics the advocates has to follow, that is there under the Advocates Act of 1961, right? So this is the right answer. Sometimes options are very easy. Next, the Epidemic Diseases Act was enacted in which year? During COVID-19, this particular law was in force, right? So that is 1897. In 1897, Epidemic Diseases Act was made. In 2019, an amendment was made to Epidemic Diseases Act, right? So in 1897, Epidemic Diseases Act was made. Now, do you think Epidemic Diseases Act is a pre-constitutional law or post-constitutional law? It is a pre-constitutional law because it was made before the commencement of constitution. Next question. National Green Tribunal was established in which year? It was established in the year 2010. First, let us understand what is the meaning of tribunal, right? So a tribunal is a court, right? Or a quasi-judicial body which is established to solve a particular matter. Like NGT, National Green Tribunal, deals with environmental cases, right? So you already know that there are some crores of cases pending before the courts. And if all cases are coming to the court, in the court, you have to follow a particular procedure. For everything, you have to bring document, evidence, and all the nonsense, right? But what tribunal will do, tribunal will try to solve the matter based on law, number one, and also on the principle of natural justice, right? Now, let us suppose that this is a village and there is a tiger that enters into this village, right? So this example was given by my teacher when I was 5 years old, 5 years back from now, right? So when I was in class 11, so 12, so this particular thing was given. So there is a tiger and tiger entered into a village. And this tiger started killing some cows and, maybe some human beings also. Now what the villagers did, they came together and they killed the tiger. Now, tiger is definitely a species that is protected under the Wildlife Protection Act. If you go to the court will look at the law, it will look at the sections and say that, okay, you killed the tiger, so you go and sit in the jail, right? And it will take a lot of time because for everything, they'll ask you bring that affidavit, file this, and all nonsense will be there. But when you go to National Green Tribunal, tribunal will adjudicate it based on natural justice. Tribunal will say that, okay, tiger has entered into the village and it has attacked certain people and certain animals. So they are under threat. That is how they have killed this particular tiger. So no punishment, go to home, right? So tribunal generally deals, based on the principles of natural justice. For many things, tribunals are established in India. NGT, there are two types of tribunals. First one is administrative tribunals. And second one is tribunals for other purposes. NGT falls under tribunals for other purposes. Motor vehicle tribunal falls under tribunal for other purposes. What is administrative tribunal? Administrative tribunal is a tribunal which deals with administrative matters. If central government employee or state government employee, if they have any problem, then they will go to this particular thing. So in central government, there is CAT, Central Administrative Tribunal. In state, SAT, State Administrative Tribunal, right? So this is known as tribunal. Tribunals are some courts which are established for a special purpose. Next, which of the following is not the legislative power of the president? I think we talked very good, Sharon. Well done. Right. To declare war and peace. Sharon, why are you not coming to the class?
So it's taking long for journey travel, sir.
Acha. Okay.
Yeah.
So to declare war and peace, right? So to declare war and peace is a part of emergency provision, right? To declare war and peace, it is a part of emergency power of president. Whereas summoning each house of parliament, parliament is the lawmaking body. Hence, it is a legislative power. Issuing ordinance. What is the meaning of ordinance? Ordinance is generally issued by the president. Ordinance is a law which is made by the president when parliament is not in session. An ordinance is valid for how many months? 6 months, right? So after 6 months, another 6 weeks time will be given. And in that 6 weeks, parliament has to make that into law, right? So giving assent to the bill, that is also a legislative power, because I told you already, when a bill has to be passed, you have to get the assent of Lok Sabha, Rajya Sabha, and of president. Only when president signs, it will become a law. So that is how it is the legislative power of president, right? So that is why I have discussed the powers in under various headings like legislative power, executive power, judicial powers, advisory power, and etc. So to declare war and peace is a part of emergency power. Next. This is again a very important question. Who appoints the chairman of the National Human Rights Commission? Very good. President is the right answer. Well done. So who is the present chairman of NHRC? Justice Arun Mishra. Justice Arun Mishra is the present chairperson of NHRC. Right. Next. Who is the 16th Chief Justice of India? I'll give you a hint. He is the father of our present Chief Justice of India. One is the right answer. Right. So Y.V. Chandrachud, he is the 16th Chief Justice of India, and he is also the longest serving Chief Justice of India. The longest serving Chief Justice. His son, D.Y. Chandrachud, is the present Chief Justice, the present 50th Chief Justice of India. Right. So this is very important. You know, Justice Koka Subbarao. So he is a Telugu guy, and he is known for his judgment in Golaknath case. And we also discussed about Justice P.N. Bhagwati. Justice P.N. Bhagwati was also the former Chief Justice of India, who is known for encouraging PIL. Right. So when P.N. Bhagwati was the Chief Justice, PIL was encouraged. PIL stands for Public Interest Litigation. Right. So Justice P.N. Bhagwati, along with another judge who is known as Justice Krishna Iyer. Right. So Krishna Iyer, he wrote a book Off the Bench. We discussed about it yesterday, right, in yesterday's class. So this is also very important. Next. Full form of UPOV. What do you think is the answer? This International Union for Protection of New Plant Varieties. Right. So here what what they'll do, if they did not attend the class or if they did not solve the paper, they'll think that this is definitely not the answer because this is starting with I. Right. Other options they'll mark, but this is the right answer. So it is the International Union for Protection of New Plant Varieties, which is not a trademark. I think you should be able to answer it if you have attended my class on IPR. Very good, very good. Excellent. Well done. Computer. Trademark is given to whom? Right. So for trade, whenever you're doing a business, you'll get a trademark. Right. Now a person is making this t-shirt. So he'll get the trademark of US Polo, which others are not allowed to use. Right. Coca-Cola is a trademark. Right. US Polo is a trademark. Or any other company, you know, Dell is also a trademark. Computer is not a trademark. It is a mobile property. Very good, Pratyusha. Well done. Next. The concept of Indian judiciary. Yeah, domain name is also a trademark. Very good. You know what is the domain name? No. Domain name is the name which is given to the website, right? For example, www.lawcetadda.com. This is a trademark. So this is the domain name, right? So this domain name cannot be used by others. Only by Lawcet Adda can use this particular domain name. So that is also a trademark. Right. So the concept of independence of judiciary is borrowed from which constitution? From the Constitution of USA. Very good. Very good. Next. Lok Adalat cannot decide dash cases. You pay very close attention. By elimination, you'll be able to answer it. What do you think is the answer? Okay, let us look at the non-serious cases. First, family disputes are not of very high criminal case, I would say. Compoundable cases. What is a compoundable case? Compoundable case is a case where both parties can compromise. So that is there. And civil cases are also less serious. What are non-compoundable offenses? Non-compoundable offenses are those offenses where you cannot strike a compromise. like rape, murder, etc. Right. So such cases cannot be dealt by Lok Adalat. What is Lok Adalat? Lok Adalat is people's court. Right. So this is a form of, this is not a court actually. This is a mechanism where your disputes will be settled. This is a form of ADR. What is ADR? Alternative dispute resolution. This is a form of ADR, that is alternative dispute resolution. Right. So Lok Adalats are given statutory status by the NALSA Act, National Legal Services Authority Act. Right. So under this, Lok Adalat can deal with some small cases. And Lok Adalat can also deal with cases which are in pre-litigation, which means you did not even file a case. Right. But you have a dispute. You'll go to the Lok Adalat and you'll solve it before even going to the court. Right. ADR is out of the court settlement without going to the court. Next. A minimum of dash members are required for unlawful assembly. What is the meaning of assembly? It is not that state assembly. Assembly is people assembling together. How many members are required so that you can call it as unlawful assembly? 5 or more. What is unlawful assembly? Unlawful assembly under section 141 of IPC, if I remember correctly. Right. So according to this section, when 5 or more people are coming and they are trying to obstruct the parliament or the state legislature or government of India or government of states, or they are behaving in such a way, the 5 members are coming and maliciously they are trying to stop the implementation of any law made by the parliament, anything against the government, if they are doing 5 or more people, if they are coming together, that is known as unlawful assembly. 5 people are required to constitute an unlawful assembly. Right. Next, which article speaks about the participation of workers in the management of industries? 43A. Very good. Very good. Well done. Yeah. Next one. What is the full form of CSR? Which one? Which option? Corporate social responsibility. Very good. Now, what is CSR? What is corporate social responsibility? So any company which has a net worth of more than 500 crores or which has a turnover. What is the meaning of turnover? Turnover is revenue, right? A revenue of 1,000+ crores or a net profit of 5+ crores. They have to pay 2% of their profits for the last 3 years for some CSR activities. That is for some social responsibility activities like educating the girl child, or maybe constructing, a park, or maybe doing, any other thing, right? So this is known as CSR. Under section 135 of the Companies Act, CSR is mandatory. If your net worth is more than 500 crore, if your turnover is more than 1,000 crore, and if your net profit is more than 5 crore, then you have to pay 2% of your profit for some social responsibility activities, right? So India is the only country, or maybe the first country, to make CSR mandatory, right? So that is what. Some people, what they do is that they'll make the mobile phone and they will say that the CSR, the flashlight is a part of CSR, right? Which means that they'll say that we added flashlight so that people can use this in the dark time. Whenever there is no power, we will see that, right? So that is also a part of CSR. Who among the following is competent to prescribe conditions for the acquisition of citizenship? If you have paid attention in my class, you will be able to answer it correctly. Very good, excellent. So it is Parliament. Under which article? Under Article 11, right? So recently in the news, Citizenship Amendment Act of 2019 is there in the news, right? So who made this? Parliament. Now, what is Citizenship Amendment Act of 2019? This Citizenship Amendment Act gives citizenship to certain religiously persecuted minorities in certain states. Who are religious minorities in the states of Pakistan, Afghanistan, and Bangladesh? Who are minorities, religious minorities in these three states? These three are Muslim dominated states. So who are the religious minorities? Hindus. Very good. Hindus or Buddhists, Jains, Sikhs, Parsis, and Christians. These people can be considered as religious minorities, right? So if these people have entered India before 31st December 2014, right? Because why did they enter India? Because they were religiously persecuted in that state, right? Based on religion, they were discriminated and they were thrown out. As a result, if they have come to the state before 31st December 2024, they are not treated as illegal migrants, which means they can apply for citizenship, right? So this is about the Citizenship Amendment Act. We will discuss it in current affairs as well. 1 second. Next. Who wrote the book Judicial Review or Confrontation? It is written by Justice H.R. Khanna, right? So H.R. Khanna is also a very important judge. Yesterday we talked about this thing, Off the Bench, which is written by Krishna Iyer. Another book, H.R. Khanna, he wrote a book, Judicial Review or Confrontation. So H.R. Khanna was the judge who delivered dissenting judgment in a case that is known as ADM Jabalpur versus Shivkant Shukla. In ADM Jabalpur versus Shivkant Shukla, Supreme Court told that the right to move the courts for the enforcement of fundamental rights, which means that when your fundamental rights are violated, you cannot approach the court during emergency. That is the judgment of the Supreme Court in ADM Jabalpur. But there was one judge who is dissenting judge, which means he gave the opposite judgment. That is H.R. Khanna. H.R. Khanna told that, no, this right cannot be suspended. Even during emergency, you should be given the right to move the courts for the enforcement of your rights. So that is why, as a result, he was not made the Chief Justice of India, right? So you have to remember this particular thing. Next, free legal aid for needy under the Constitution is discussed as a part of easily one option you can eliminate or two options you can eliminate, right? So relation between center and states, this has nothing to do with free legal aid. Fundamental duties, no, because free legal aid should be provided by the state. It is not duty of the citizen, right? So it is directive principle of state policy, under which article 39 capital A talks about free legal aid. Judiciary is also the wrong answer. Next one. The three legislative lists are mentioned in which schedule? 7th schedule. Very good, very good. Well done. Right. So remember, after going home, go to the schedules chapter, look at tiers of old PM. I think this is a third question on schedules. Right. So schedules is a very important chapter. Without being perfect, you should not go to the exam. Okay. Tomorrow I will ask questions to everybody regarding the schedules chapter. Okay. So prepare and come. 105th Amendment Act was made in which year? So 105th Amendment Act was made in 2021. Can you tell me 105th Amendment Act is related to what? Hmm? 105th Amendment. So by 105th Amendment Act, we have restored the power of states, right, to recognize socially and educationally backward classes. Earlier it was there with the center. Recently, we gave it to the states, right? Yesterday, we talked about 104th Amendment Act. 104th Amendment Act removed Anglo-Indian reservation in Lok Sabha and state assemblies. 104th Amendment Act was made in the year 2019. 105 in 2021. 106. What is 106? Very recent one.
Reserve 1/3 seats for
Very
women.
good. 1/3 reservation for women in Lok Sabha and state assemblies. Right. So 103rd is related to economically.
EWS reservation.
Right. This was also enacted in the year 2019. 102nd Amendment has given constitutional status to NCBC, National Commission for Backward Classes. This was enacted in the year 2018. 101 GST in 2016. Right. So you have to remember these dates, very important. Next. Which section of IPC deals with dowry death? 304B. Right. So what is dowry death? Killing somebody for dowry, not giving dowry. So if a woman, if the wife dies within 7 years of marriage, unnatural death, then it is considered as dowry death by default. But you can prove it that it is not a dowry death. But unnaturally, if she is dying, you can claim it as a dowry death. And especially when the woman dies by hanging up or when she is lit in the fire, so that would amount to dowry death. I think this question we discussed in family law chapter. Once again, instantaneous triple talaq was invalidated by the Supreme Court in which case?
Shayaro Bano versus Union.
Very good. Shaira Banu versus Union of India. What is triple talaq? Instant triple talaq. What is the meaning of talaq?
Divorce.
Talaq is instant triple talaq is husband will say talaq, talaq, talaq 3 times and divorce is granted. Right. Supreme Court told that this is invalid. Okay. So in which case? Shaira Banu case. Muhammad Ahmad Khan versus Shah Banu Begum. This is related to maintenance of Muslim women. Right. So after divorce also you have to maintain your Muslim wife. Right. Hussainara Khatun versus state of Bihar. This is considered as first PIL India and this is related to prison reforms. Right. So court told that you cannot punish the prisoners without the permission from the court. Right. Next one is Daniel Latifi versus Union of India. In Daniel Latifi is also related to maintenance, where Supreme Court told that after the iddat period or the idda period, you should pay maintenance. Right. What is the iddat period or idda? So this is the period where the wife has to maintain a gap after the divorce of husband and after the death of husband in Muslim law. Right. So after the divorce of husband, wife should not remarry for how many months? 3 lunar months, for 3 months, 3 full moons. Right. And after the death, it is 4 lunar months. Right. This is known as iddat or idda period. Right. After this only you can remarry. Okay. That is one thing. Yes, Soumya. Next one. Ordinance promulgated by the presidents remain valid for. I talked about it very recently. Ordinance. What is ordinance? What is the meaning of ordinance? Yeah. In the absence of the parliament, president will make the law. Right. Very good. Very good. 6 months. Next, last question. Special provision with respect to the state of Goa is given in which article? This is a slightly difficult question, I would say, because we were not expecting this type of question in the exam. So what is the right answer? 371I. Right. So from 371 to 371J, special provisions are given to some states. So that is what you have to remember. Next, yeah. This is the last question. Now, after going home, you read the passages and answer the questions and let me know after completing this particular thing. Tomorrow, by studying schedules only, you have to come to the class. Without knowing that, you are not allowed to enter into the class. Okay? Remember this thing, and mostly tomorrow, Rajesh sir's class will be there. Today also his class only, but he has cancelled the class due to some, he landed a little late today. So that is why. Tomorrow, if Rajesh sir is coming, he will take. Otherwise, I will come and ask the questions. Okay? I'll see you tomorrow. Bye-bye.